Welcome, guys. Welcome to the Brand Identity Design Podcast. My name is Jason. I'm your host for today's show. And today we would be discussing the power of intellectual property with Anna Juneja. And we would be discussing the different types of intellectual property, some of the advantages, and how owning an IP enhances your company's value, provides you a competitive point or differentiation in the marketplace. So I want to first of all welcome Anna. I have met her on LinkedIn and she is an amazing content creator specifically about trademarks, intellectual property laws, a lot of business related information. So I want to say thanks to Anna for, accepting my invitation to be a guest on season 3. So thank you so much, Anna, for being here. Uh, you know,
Thank you for having me.
Absolutely, absolutely. And I specifically got this sound effect for you, and I wanted to play that. I kind of missed it, so let me just play that sound effect. There you go. That's Anna. so,
Thank you.
so thank you so much once again. So we are broadcasting live not only on Clubhouse but also on LinkedIn. I want to say hi to my good friend Karen, who is on LinkedIn, Keith, and I see a few others who are new to my space. I also want to say hi to Tiffany. She's a very close friend of mine on Clubhouse. Alma Luz, who I see on Clubhouse, and all the other friends who joined our conversation. So thank you guys. So let's actually get into this conversation. I want to just briefly give you guys an industry overview. So according to the U.S. Chamber of Commerce and Global Innovation Policy Center, intellectual property creates and supports high paying jobs. IP intensive industries employ over 45 million Americans and 100 and hundreds of millions of people worldwide. The average worker in an IP industry earns about 46% more than their counterparts in non IP industry. American IP industry is worth approximately 6.6 trillion US dollars, which is more than the nominal GDP of any country in this world. Just in case, guys, if you were unaware of this, 6.6 trillion US dollars. IP intensive industries also account for over one third, which is around 38% of the total US GDP, and 52% of all US merchandise exports are related to IP, amounting to nearly $842 billion. So, I want to quickly give you guys who is Anna. So Anna is actually the number one trademark lawyer on social media. She specifically, creates content for Gen Z and entrepreneurs, digital creators, and she's an intellectual property attorney. She's also passionate about helping business owners, celebrities, influencers, creators monetize their intellectual property. And she has also filed and registered over 6,000 trademarks in over 200 countries. Anna has also been featured on major news networks throughout United States for representing high profile cases for her viral social media content featuring business and legal tips. So thank you once again, Anna. I'm so sorry, I had to really share, to my listeners as to who you are, what you do, and why you are such an expert in this field. I really love your content. It's fresh, refreshing to the eyes. Typically, when you actually hear about lawyers, it's pretty boring and outdated. I think you bring a fresh perspective to the mixture, something very, very refreshing. So thank you for all your content on social media. So I want to actually start off with my first question, is that why you decided to become an intellectual property attorney. Law can be very boring. Any childhood influence. I know you were born to two physicians based on your bio, and you also received a bachelor degree in biology. So I mean, it's understood that you were getting into the medical direction, but what made you like pivot to law and become an IP lawyer? Like, I want to hear that story if you may, please.
Well, thank you for the kind introduction. Such nice words. Thank you so much. I should listen to this podcast again so I can have the bio you just said about me. So my journey into IP law basically started obviously in, before law school actually. So yes, I was born to two physicians. I potentially was going to go into maybe not medicine, but more of the scientific route. However, you know, academics in science as well as medicine are very difficult lifestyle careers for women, especially. And it just didn't work out for me with, what was going on in my life at the time. But law school was a little bit more flexible, and that's basically the reason I went. I think I just didn't want to be a housewife. I don't necessarily have a great reason for why I went to law school, but pretty much on day 2 of law school, I discovered IP. I was recruited basically into doing IP because if you have a science background, they start to kind of hunt you down. So, to actually do certain types of intellectual property, such as patents, you have to have a science background. You actually can't take the patent bar without having a science degree. So, since I had that science background, I was pretty much immediately told I was going to go into IP. And then, as soon as I started studying it, I immediately fell in love with it. I loved the business interplay with it. I loved the global affairs interplay with it. I loved being able to help people of, they're just starting their business. And I loved that I could also help corporations. It's with lawyers, you either do everything for one kind of person or you do one thing for everyone. So it's like breadth versus depth. So obviously, IP lawyers have very, very deep knowledge of intellectual property and business and those financial type of transactions that relate to IP. And we do it for everyone. And that really appealed to me versus something like a family lawyer where you kind of do everything for families or children and couples. So just a little bit of a different viewpoint in terms of why people get into IP, but you are completely right. And especially IP, like intellectual property, the field of law is very old. I'm definitely one of the younger ones in the field. Like there's not very many young attorneys in IP. It feels like everyone's very seasoned and they're very traditional, but there are a lot of emerging issues with new technology in IP, and it's very important for younger attorneys to be getting involved with it. And that's another aspect of why I love it. And in law school, I actually worked at the United States Patent and Trademark Office. I studied intellectual property, basically from the very start of law school. So I've been very immersed in the field since I began my legal career.
Absolutely. Wow. Wow, that is phenomenal. And you said so many things, telling us as to why you decided to get into law. And sometimes, life takes you to a certain direction and you kind of fall in love with certain things. And I kind of understand where you're coming from. I mean, needless to say that when I was going through your bio, I also read about your contribution. You served as an extern for a USPTO and Trademark Office, and you also received a Leadership Achievement Award, the highest possible award for a law student. If you can speak on that, how did that? How did you end up doing that? Like, did you have to do something different being a student? Any challenges?
Yes, definitely. There's a lot of things that you should do. So many, many people, whether they are an undergrad or law school, graduate school, I know India doesn't have, or a lot of countries, they don't have undergrad, but whatever school that you're in, there are a lot of extracurriculars that are going to be offered to you as a student. And many people sign up for whatever they're told to sign up for. And that is really a waste of time. You really need to be extremely strategic with what activities that you're doing in order to make sure you're getting the highest return on your investment of time. So, being involved in things like student government is going to give you a much higher return in terms of professional credentialing than something that's, pre-law club. So you want to be very strategic with what you're doing. In law school, you have to do law review. That's a must for any American law student that's ever going to listen to this. You must do law review. Do whatever you have to do to get yourself on law review. I highly recommend actually just getting onto law review at the lowest possible position, so you have the least amount of time invested, but it's still on your resume. In undergrad, you want to make sure you're getting into very high caliber activities and you're not wasting time on random clubs. You also want to make sure that everybody who is somebody knows who you are. And this is really hard for people to do, especially as a student, because you think, why would anyone care who I am? But you just need to make sure that they know who you are, make sure that you're involved, just make sure that the important people at your school, even at your job, make sure that they like you. And that is just such an underrated skill. I don't know why people don't do it more, but I credit a lot of these award type of things to that, because at the end of the day, my GPA and my bar exam score and my trademark registrations are going to merit for my abilities in terms of just straight academics. But everything else, all of these awards, all of these different opportunities that you get are really very personality based. And that is just the way the world works, especially in America. So it is very important to be extremely friendly, do volunteering events with, the executives at your company or with the deans and professors at your school. Just get in with the right people. It's all about networking. I always say the quote, your network is your net worth. And that is really what is going to set you apart in school and your career. Forget about the random clubs, forget about going on, spring break trips and things. You really need to make sure the important people know who you are and that they like you. That's the biggest tip that I can give anyone in any career field, actually, and in any job or any path that you're on.
Absolutely. I'm with you 100% on that quote. Your network is your net worth. And actually having connections does help you to problem solve a lot of things which you might encounter while you do business. You never know who's gonna come handy when I say handy, you can always seek professional help, and it just makes the process a lot more easier. And we kind of need each other to grow as entrepreneurs, because business is a collective effort, even though you are a single entity by yourself. But in order for you to grow and scale, you do require help. It can be your team or it can be people in your network. Let's actually get into the juicy side of our discussion about intellectual property rights. Okay, now, could you tell us in layman terms what is the purpose of intellectual property? Why should actually people care about this so much?
Yeah, so this is something that I'm surprised isn't taught more in schools, and it's not more ingrained into everything that we do as a society. But intellectual property is basically the system where you are encouraged and incentivized to innovate. So that means people who are pushing the envelope and people who are building businesses, building brands, inventing new products, pushing humanity forward, literally, saving lives, helping society, creating jobs, people who are creating anything, they need to be incentivized to do so. And how you do that is by creating a system where intellectual property is rewarded. And in the US, every country is different how they do this, but in the United States, intellectual property rights are ingrained into our constitution. They're an integral part of the country. It's why America is, the greatest country in the world. It's why people from all over the world, just like I did, that's why people come here, so that they can start something and build something. And when you have different things that you do, such as when you build a business and you create a name or a logo, that's intellectual property. When you write a book, that's intellectual property. When you develop a new medicine, when you create a new tool, all of that, that's intellectual property. So basically, you can have things that are more tangible, like you can go out and you can buy land and a house. That's real property, that's real estate. That's one way to have an asset that you own. But a lot of people, have things that they create and they build on their own, which are intangible. You can't hold them, but they're still very valuable. And it is still very important for society to continue to develop and create different types of intellectual property. So the system is basically that you citizens, companies, all of that in different countries, you create intellectual property by starting a business or developing something in a lab, etc., writing a book, creating art, writing a song, things like that. You create intellectual property, and then the government says, okay, we are gonna protect your intellectual property, and therefore keep doing it because we're going to protect it and you're going to be able to monetize your intellectual property. So that's why intellectual property is so important, and that's the gist of what it is. And I know we're going to get into the specific, like, different types of intellectual property and things like that, but
Yeah.
that's as a whole. It's basically intangible assets, things that you can't hold but that you've created and that you have and that you own and that are very valuable to you as a business owner and also to society.
Absolutely. I love that explanation so much. You kind of gave a premise of what is a tangible asset and what is an intangible asset, and why both requires their own specific level of protection. I also like what you said. It's a system to innovate and incentivize, because you are creating something, and you need to also ensure that it's protected, and people don't take advantage of it, and there is a reward for actually creating it. So I love that. I love that very, very much. Let's actually, break things down. So, what are the different type of intellectual property rights? If you can break it down so that people can understand, that would be so cool.
Yeah, there are four main types of intellectual property that we can point to. One is going to be copyrights. So this is going to cover copyright law covers anything that is an original work of authorship. This is everything from books, movies, videos, songs, architecture, tattoos, NFTs, software. This is anything that is considered art. This is going to be covered by copyright law. Then another type of intellectual property is called trademarks, and trademarks are brand identifiers. So if you have anything that is a name or a logo, a slogan, even a color, shape, jingle, anything that identifies your company as the source of whatever good or service that you're providing to the public. So everybody knows, that green Starbucks logo, the Coca-Cola red. Um, Everybody knows the I'm trying to now think of famous trademarks and I can't think of any. The Nike swoosh, the Just Do It slogan. So we see trademarks all over, and I would really argue trademarks are the most common type of intellectual property that every single business owner, every single creator, every single celebrity, everybody has some sort of trademarkable assets. And when you think about today's day and age in 2022, everybody does have a personal brand, a brand. It's very important to think about securing a strong trademarkable brand and building that versus investing into something that's not easily protectable or not valuable. So that's where trademarks come in. Then we have patents. Patents protect inventions. So this is going to be if you've created a new formula of makeup or you've invented a new type of doorknob or tool. So anything that is an actual invention, it's actually called a utility patent. There's another type of patent which is called a design patent. This will cover more just the aesthetics, non-useful aspects of something. So I used to do a lot of design patents for a toy company, and I did a lot of design patents on toy cars. So just the unique shape of them. They're not functional. Obviously they're not a car. They're just a thing, and we're just protecting basically the shape, the design, that type of thing. So that is what you can protect with a design patent. Obviously, utility patents, they must have some sort of use. They must be some sort of invention. And then the sort of last type of intellectual property that we can talk about is trade secrets. And this is going to just be something that is secret and that has value. And by keeping it a secret, therefore, it has the value. So the most famous example of this is the Coca-Cola formula that is locked in a vault, and Atlanta, Georgia, and it's a tourist attraction now, the vault is. So that is an example of a trade secret. But trade secrets can actually be even things like vendor lists and things that, proprietary information maybe that your business has. And to protect trade secrets, there has to be certain steps taken. So, you have to have the right contracts in place. You have to make sure your employees are following the correct guidelines. So there's a lot that goes into trade secrets as well that I feel like doesn't get discussed as much, but it's still a very important, valuable type of IP that a lot of businesses have. So that's an overview.
Yeah, that is a fabulous overview. So, guys, just in case if you didn't catch it, so number one is copyright, number two is trademarks, number three is patents, and there can be a couple of subcategories within it, utility patent being one, design. I've also heard about plant-based plant, like, that's also another
Yeah,
thing.
plant patents are a little bit more rare, so we don't usually cover them too much.
Yeah, I think so too. Okay. So yeah, I heard about that. And final one is trade secrets. So guys, probably it's possible I might do more shows with Anna and go deep down with each specific component in the long run, but we will keep you posted on that. Let's actually move on to the next question. Now, just in case, guys, if you're listening on LinkedIn, we would start Q&A I think about in 20 minutes from now. So if you have any questions, hold on to that thought. I will open up the space on LinkedIn and on Clubhouse so that you can clarify your doubts with Anna. I just have a few more questions for her. So the next thing which I want to actually highlight is that there is one common mistake which I have noticed business owners they make. They assume that registering their trade name legally, like an S corp, C corp, or LLC, or a proprietorship, they automatically think that they get protection, they get IP because they have registered it. Could you clarify that?
Yes. So there's a couple of things that people do with their business name, basically. So, when you create a business, you don't necessarily need to have a brand attached to that business, depending on what it is. If you are, for example, opening an LLC because you want to invest in some real estate, I mean, there is no brand associated with that, but that is, still a business. However, a lot of businesses where you are offering goods or services to the public. So, if you're selling a product or a service to the public, you are very likely going to have a brand that's attached to it. So, this may be your personal name. This may be a name that you've come up with. This may be a logo, a slogan. Usually, businesses have multiple brands, brand identifiers, and all of those are trademarks. However, your business name, in terms of your corporation name, your LLC name, that itself is completely irrelevant. So I always say, you can have a LLC called 123 Garbage LLC, and that's fine. You can still have 100 different brand names that are owned by your LLC that you're using in as a name to connect your goods and services, so that, for example, when you open a computer store and you call it Apple, that people actually know who you are, what you do, and the quality of products to expect. If your friend next door opened up an electronic store and called it Apple, you'd be really upset, because then people aren't going to know the quality of your products and people are going to confuse you. It's really bad for your business. So that's what a trademark protects. Now, you do get some limited protection just when you use a brand name in public. However, your LLC name itself is completely irrelevant. Registering an LLC does not mean you're using that name. It does not mean you've protected that name. Anybody in any state or country can actually go and register the trademark for your LLC name and stop you from using it. So your LLC provides you a different type of protection. It provides you liability and financial protection and business protection, things like that. But your trademark protects your brand. So when you're investing into your brand, you really don't want to invest into anything you don't own, because if someone else can take it away from you, then you're just building a brand for somebody else. So that's why it's really important to make sure you have all the correct layers of protection that you need in your business. And that's a very common mistake, is that people have an LLC and then they think they own their name, and then they get a cease and desist, or they get a lawsuit, or then they want to get onto Amazon, or they want to actually sell their company and they can't do it because they don't have the trademark and somebody else has it.
Absolutely, absolutely. And sometimes many business owners decide on a name which might be available as an LLC, but when they try applying for a trademark, probably that name is owned by something else. So, as a designer, what I always recommend my clients is that you have to do two kind of searches. One is to actually check if the LLC is available, example, and the second kind of search you have to do is you also need to check with an IP lawyer if that is a name you want to use for your brand. Just check if that is also available. And the third thing which you also possibly, which I suggest to my clients, is that to do a search on social media, just to make sure that you have URLs available which you can use for your brand. So I think that's the direction which I generally recommend. As a designer, what I have also observed, another complication, designers are not really equipped with the resources to understand IP law. And I just say it honestly, like, I don't know what is IP law. Give me a second, Anna, just a sec, okay? I think it's my dad.
I'll fill in while we're chatting, while he's I'm chatting. So he just made a great point about
Yeah, I'm back. I'm so
social
sorry.
handles.
Did I miss
Oh,
anything?
no,
Yeah,
go
so I
ahead.
was saying designers are not really equipped with the resources to understand IP law. And I don't think designers should become attorneys and recommend things to client, because I don't think they have the understanding and awareness how IP works. I think in most cases, what I generally do is before even starting an identity project, I always direct them to an IP attorney first to check if there is availability, and if there is availability, what kind of marks does exist. We kind of need like a report before even start developing an identity. If you can speak on that, that would be really cool.
Yeah, that's a great point. So I want to touch on the social handles and domain, because these are newer types of intellectual property assets. We can, IP attorneys, we can get social handles and domains once a business obtains a trademark registration, but it is still very expensive and it is difficult. So those are definitely things that you should ideally secure early on in the process. If we do have to do a social handle acquisition or username swap or a domain acquisition, it is usually minimum 5K. So that is something that really people need to think about much more early on in the process than they usually do. Even if you're not using those platforms, secure all the socials, get the domain and variations of. So just wanted to put that out there. And then talking about brand designers and graphic designers in general, you make a great point. It is really, really important before a client is investing thousands and thousands of dollars into graphics and branding and designing for a particular name or logo, that it is cleared. And it is actually something that is going to be protectable and has value. There's certain names in and of themselves that do not have any inherent value. You cannot sell them, and you will have a very difficult time valuating your business, selling your business, if anything is generic or if anything has a lot of defects in it. So identifying that problem early on and selecting a smoother name is going to save a lot of money and headache in the long run. I always say the cheapest, easiest way to make sure that you can get a trademark for a name is to do it about 1 to 2 years in advance of publicly launching a brand. But the sooner the better. And recently, some case law has come down that may hold certain third parties accountable. So if a brand designer does design or give quote unquote approval of a name that a client selects, and then the client invests $10,000 $20,000 into that, and then it ends up that they're getting sued for it because they are copying some other brand, then the client can potentially go after the brand designer. So the case law is still a little bit gray, but it does not look good for the brand designers, in my opinion. So I think that graphic designers, brand designers, all of the people associated with helping people build brands need to be much more cautious, at least having your correct disclaimers and all of that when you are working with clients that are investing into a brand that may not be available or may be defective or problematic in other ways. You want to make sure, as the brand designer, as the graphic designer, that you are covering your bases as well. And you just want to make sure that people know before they invest into something that it is available.
Absolutely, absolutely. And that actually brings me to my next question. So, what the hell is TM and the R symbol, which you see next to a mark? Okay, and and I have seen many people also use SM instead of TM. So there's a lot of confusion there. So would you mind making it simplified and just explain our audience what does that represent and when to use it at what point?
Yeah, this is such a good question because I feel like more people should know this, but the TM does not really mean anything. It just means that that person is intending to use it as a trademark. Um, the only thing that really means anything is that circle R. That circle R means that that person has a registered trademark. And unless you have an actual registered trademark, you are not allowed to use that circle R. And people do it all the time. People put that circle R all over the place. It is illegal because that means that you are putting out to the public that you own that brand as a trademark and you're correctly and properly using it as a trademark, all of that. So people should not be using the circle R in any case unless you have a registration. And you will know if you have a trademark registration because you will get a fancy piece of paper with a gold seal on it and all of that. You will absolutely know if you have a registered trademark. And unless you have that, don't use the circle R. SM
Mm-hmm.
means service mark. This is less common, but basically it just means that you have a trademark that instead of selling goods, you're selling services. However, I actually recommend using the Circle R instead of using SM because the Circle R is a no brainer, absolute, and the SM can be interchanged with whether it's registered or whether it's not. So you can use the registered R on both goods and services trademarks, but the SM is just a placeholder basically for service marks. And then TM means trademark and it's just a placeholder for trademark. So before you file, after you file, but before a trademark's registered, you can use a TM. Before you file, even you can use a TM. It doesn't have any legal significance. Um, there's a little bit of strategy that goes into that though, because there's certain marks that, certain trademarks that may be higher risk during the registration process. Maybe we are trying to fly under the radar sometimes, or be a little more strategic. And maybe we don't want to put out to the public that we're using this as a trademark and we filed it and things like that. So there's a lot of strategy that goes into using TM, SM, etc. But um, you know, in general, nothing really means anything except that circle R, and that should be used whenever you do have a registered trademark.
Yeah, that is a lovely explanation, and I think that clarifies this whole thing. Now, let's assume that I have a business in multiple countries. So, in that case, how would the R symbol? So, it's possible I might have a registered trademark, let's say in the US, and I decide to actually, let's have a business in, let's say, Australia. So, am I allowed to still use the R symbol whenever I broadcast my logo out there? Or does it only give you protection within the country you requested for protection? How does that work? If that question makes sense.
Yes, so trademarks are territorial, which means they protect the country you get registered in. However, you're allowed to use that circle R in most countries. Some countries have stricter rules, like you must use it in your country, but in general, if you have a registered trademark, you're going to be allowed to post your content and your logo on social media and things, even if someone from Australia sees it, things like that.
Awesome, awesome. Now let's actually get into objections. Whenever you apply for trademark it's possible that you can get objection from the USPTO or the trademark office, in your specific country. So could you help us understand what are some of the common trademark objections, what are the reason behind it, and what can people do to prevent them?
Yeah, this is a great question. So in the United States, I think 70 plus percent of trademarks do get rejected initially. They receive an initial refusal. So it does not mean that your brand is doomed or anything like that. It just means that you need to correct any defects that were identified. So the most common situation that comes up really is administrative situations. So this is going to be where the examining attorney, the attorney that works for the government, works for the United States Patent and Trademark Office, they need some clarification on something. Maybe they want you to just amend some of the goods, or they need some additional specimens, evidence of use, some additional information about your website or how you're using the brand. Administrative um, aspects can come up, or they may need you to disclaim a word, which means, for example, if I was going to, for example, I have a law firm, it's called Ano Law, and I have a trademark for Ano Law, but I had to disclaim the word law because that means I don't have an exclusive right to use the word law on itself. I can only use Ano Law as a brand. I can't use just law. So, that's what a disclaimer is. So all of these are very, very minor administrative type of refusals. Seasoned trademark attorneys can handle this type of refusal with a simple phone call or email exchange. Usually a phone call is best, and get it handled through an examiner's amendment and things of that nature, and can handle things very, very quickly. And usually they will not charge you for it if you've filed your trademark with them. We don't charge at my firm, and I know most firms don't. So in those cases, you may just receive an email about it from your attorney, but in general, those administrative refusals are the most common, I would say. The second most common type is called likelihood of confusion. And this type of refusal is more difficult to overcome. It means that there is another similar mark out there that is either registered or pending or whatnot that the government has decided is very similar to your brand, and you have to now write arguments to overcome it. So these type of refusals are obviously more expensive to overcome because you are now paying an attorney to write the arguments to overcome the defects. But likelihood of confusion is a very common type of refusal. And then another very common type of refusal is called basically genericness, descriptiveness. This is very common with new and small business owners. So when you pick a weak brand name, and when I say weak brand name, I mean financially and legally weak, not saying it's not a great, catchy, cute name, just saying on the merits itself, it's a weak name, less valuable, things like that. You may get a potentially genericness or descriptiveness type of refusal. So when I say genericness, I mean you cannot open a juice store and call it juice store. You have to have an actual brand. The government is not going to allow you to exclusively own some sort of generic word that describes the goods and services that you sell. So a lot of small business owners, they really like to use generic, common, descriptive type of brand names.
Yeah,
And this is
even
actually,
geographical. I'm so sorry. Yeah.
yeah, and geographical as well. You can get refusals for that as well. So you cannot do that. I mean, you can do that. You actually can. There are ways around it. There are strategies that we have in terms of we can go on the supplemental register. We can show ad spend to show that it's quote unquote acquired distinctiveness, things of that nature. However, overall, that's very expensive to do. It's cumbersome for a small business owner. So just be very strategic of how you're picking your name. You really want to pick a strong name, and you don't want to pick something that has inherent defects in it. And that will avoid a lot of these refusals. And then just making sure that you are working with a trademark attorney that has experience in trademark and intellectual property law. just make sure they're not a, social media type of attorney. Make sure they actually have law firm experience, things like that. I would recommend, because you do not want unnecessary administrative refusals. You don't want your application documents filed with any errors and things.
Absolutely, absolutely. Guys, we would be starting the Q&A shortly. So if you have questions on LinkedIn or Clubhouse, feel free to raise your hand and I would be happy to bring you up. LinkedIn does have a limitation, so I can only bring X amount of audience at some point, at some given point. So yeah, so I remember Noel had a question, so feel free to raise your hand. I'll bring you up. I want to say hi to Dr. Danette. I also want to say hi to Karen once again and everybody else who is listening. Thank you so much for being here. One last question which I have before we start with Q&A with the audience is about trademark infringement. So can you explain what is a copyright and trademark infringement, and why use the cease and desist letter?
Yeah, great question. So when you have, put effort into building a brand or creating some sort of content or art, you want to make sure that you, of course, register it, but that you protect it as well, because nobody else should be profiting off, your hard work. So when you've built a brand and somebody else copies you, you see another Instagram account pop up and they sell the same thing you do, they're using your name. You want to be able to shut them down. And the cheapest way to do that is really a cease and desist letter. Same thing for copyright. If you see somebody stealing your videos and things, you can send them a cease and desist, or there's a couple other avenues with copyrights as well, with DMCA takedowns and whatnot. So infringement is its own very deep strategy. We could do a whole session on that. But basically, the gist of it is that if you have worked really hard to build a brand or make videos or art or content of some sort, don't let somebody rip you off, because that's your intellectual property, and there are ways to protect it and make sure that any revenue somebody else made off your intellectual property is paid back to you.
Absolutely, absolutely. And I totally agree. We need to have an episode just alone, just to speak on infringement and how to go about it, because it's such a vast topic and there's so many components which we can cover within it. I want to say hi to Alma. Thank you so much for joining the stage on Clubhouse. I also want to say hi to Noel. Thank you so much for joining on LinkedIn. Since Alma was the first one to join the stage, and she already has a question about service mark and trademark. Go ahead, Alma. Why don't you ask your question to Anna directly and clarify?
So I was just wanting to make sure that I understood clearly. Thank you for bringing me up, by the way. I wrote down that the R only is used with trademarks, the SM for service, and the TM can be used without registration. Am I following correctly?
Yes. So service marks are actually a type of trademark. So when you have a trademark, you have a brand that's associated either with some sort of good or service. There's different categories for different types of goods and services, but your brand will be associated with one of the 45 categories, and it will be either a good or a service. And of course, you can have multiple categories as well. But if your brand covers a service, like for example, Anna Law is a trademark I own that covers legal services, because it's a law firm. So that is a quote unquote service mark. However, I would personally not use the SM. I would just use the circle R, because that's a registered trademark and it's a more identifiable symbol. Now, if you have a brand that just has services, like Anna Law just has legal services, you can use the SM alternatively. I don't recommend it. I don't think it's as publicly recognized and respected. And, you want to deter people from copying you. So the circle R is a better way to do so, in my opinion. But there are other IP attorneys who recommend people do use the SM. I just don't think that you should, in the day and age of social media when things are viral and misinformation, all that. Everybody knows the circle R. So I recommend using the circle R. And if you have a pending trademark or a pre-filed trademark, you're allowed to use the TM, but it doesn't have any legal weight. And just be cautious using the TM because, like I said, there's pros and cons, but because it does put people on notice, but there's a downside to putting people on notice of what you're doing as well. So there's some strategy that, has to go in behind that. But yes, overall, SM is for service mark, but that is a type of trademark. And circle R means registered, like you have the registration. And then TM you can use even before it's registered. I've also, Jason, I don't know if you have experienced this as well. I have spoken to graphic designers and marketers who've actually said that in copy, in ad copy and whatnot, the TM performs better than the circle R. So there's some discrepancies there in the public as well with that. But legally speaking, if somebody copies you and you have a registered trademark and you have that circle R on it, you are going to have a lot easier time recovering your funds in court.
I agree with you 100%. The R is much more stronger and has more weightage, and you have more leverage. Yeah. So,
Thank you.
so Alma, does that answer your question? Do you have a follow-up question before we move to Noel?
Yeah, it answers my question, and I actually do have a follow-up question.
Please, please.
And so the other question is, because I'm starting off as a graphic designer, and I've had a few clients, not a whole lot, but doing logo design. I had one ask me if I would be responsible for the trademark, and when I did my research, I saw that it really just depends. So, as a graphic designer, is it my responsibility to check clients' brand name for the trademark, or is that something that they do before they come to me?
So actually you are not allowed to check their trademarks. So that would be considered unauthorized practice of law. So if they need a trademark or they need a trademark clearance opinion, that has to come from a licensed attorney in their country. At least that's the law in America. So graphic designers are not responsible. Uh, unless you literally have years of experience and have done thousands and thousands of searches like an IP attorney, there's no way you know what you're looking at when you do any sort of search. So we also have like special AI and software. We have not special methods. We have a method to be able to provide a professional legal opinion on whether a name is available or not and whether the client needs to proceed in investing thousands of dollars into this. So it should be part of your disclaimer and part of your checklist, your pre-onboarding checklist and things that they know that they should be going to an IP attorney in their country. So they need to do that on their own, or you partner with one that provides, some sort of discounted special rates for your clients, things like that. But you as a graphic designer, as a marketer, are not legally allowed to do anything with their trademark at all. You're not allowed to provide them any sort of guidance or advice whatsoever.
Absolutely, I agree with you, Anna, and Alma, I kind of do the same thing. You need to draw a line. There are things which you are capable of doing at your end, and there are things which you are not capable of offering, and you need to let people who are capable of doing it deliver it. So if somebody were to ask me that question, I would actually reach out to Anna and I'll ask her. I'll ask the client to take assistance from Anna to do a search. And if you know something about trademarks, when you do searches, there are around 45 classes on trademark, and each of your goods or services which you offer falls under those categories, and it is a very complex thing, and I don't think designers are equipped to know. You may have an overview, but I don't think you would know everything in detail, and I think it's not advisable to do a search by yourself, because having a documented proof by a lawyer, if I acquire a proof from a lawyer, it just helps me do my work with confidence. It makes it a lot more easy. So what do you think, Anna? I mean, did I say it
Yeah,
right?
that's absolutely right. So if I give a client an opinion letter that says your name is good, go for it, get your graphics, get your inventory, et cetera, and then something happens and that name isn't available, or I say something incorrect in the search, they have recourse. They can tell me, hey, you didn't do this right. And if I did something wrong, they have recourse. That's why licensed professionals have malpractice insurance. So Thank God that's never happened to me, but if an attorney were to do something wrong like that, then the client has recourse. With a graphic designer, there are 45 different classes, of course. You can have an overview of it. The classes are not an end all be all. It is a very complex thing. And at the end of the day, if a graphic designer says, yes, your name is good, I did a search, or no, it's not, there's all these names. I mean, there's no way you can know what you're looking at, really, unless you really have that. I mean, maybe people would have that experience, I don't know, but I don't even know what I'm looking at when I search at the USPTO. The system is so poorly structured. We have different softwares and databases that have organized USPTO info. It's very difficult for a non-IP attorney to navigate that system. It's such a nuanced, complex thing. Trademark searches are not crazy expensive either, and if you're investing thousands and thousands of dollars into branding and advertising, it's really worth that quick 2 days pause to deal with an attorney and get that done before moving forward. Graphic designers, yes, you should definitely have an overview. You should know how to kind of issue spot things, but at the end of the day, if you do give some sort of trademark advice to someone and it turns out wrong, you are on the hook for unauthorized practice of law, plus I don't know what else. You could, be in a lot of trouble for that. And it's probably not worth it. I know a lot of people do this, like a lot of paralegals do it, accountants, things like that, and they get in trouble for that kind of stuff. I've not heard of any graphic designer doing it. But I would caution against it, absolutely, because it's illegal.
Absolutely, absolutely. I love that explanation, Anna. Alma, I hope that answers your question.
Yes, thank you very much.
All right. Do you have anything else you'd like to ask before I move on?
No, thank you.
Welcome. Noel, thank you so much for your patience. Welcome to
Thank
the
you.
Brand Identity Design podcast. Do you have a question for Anna? Is there anything you'd like to clarify or contribute?
Yes, thank you so much. This has been really fascinating. I get questions all the time. I'm a designer and a copywriter. I get questions all the time from clients like, can I trademark this tagline? Can I trademark this hashtag to use on a social campaign? And I, as far as I know, I can't give advice, but in terms of telling clients what is a normal business practice, do you recommend that small businesses? I know there's a lot of fees involved too. So, do you recommend that small businesses do circle our registered trademark applications for things like taglines, slogans, and hashtag campaigns?
So the most important trademark for a small business is going to be their brand name, like we call it a house mark. And this is because it's in all their marketing, it's their domain, it's everywhere. So your actual brand name is the most important trademark that every small business, it doesn't matter how small you are, should absolutely have a trademark for. Because changing your brand name is extremely expensive and difficult. And the smaller you are as a business, the less cushion you have to deal with your branding mistakes. So, the brand name itself should absolutely be registered. You should be getting them in touch with an attorney, get them to register their trademark. When it comes to the logo and slogan, those are much more secondary, especially the logo. In cases where the logo is just the word in a stylized font, that is very, very weak as a trademark. It is very low protection. I see so many people, especially DIYers, they file their logo as a trademark and they think they have some sort of protection. Unless you have a word trademark, which are more difficult to get, it is not providing you with adequate protection whatsoever. You are only protecting those particular characters in that particular stylized font. So that is a secondary thing. Now, if you have something more distinguishable, such as like the Nike swoosh, things like that, where it's an actual design element, that's something to potentially considering trademarking even as a small business. And then slogans as well, same thing, depends on, the usage of it. I say this to determine if people should trademark something or not, because I know there's a lot of drop shipping stores and temporary businesses in today's day and age as well. If you actually have a business that's going to be a real business, like you're doing this to make an actual living or to have it long term for yourself, and there is some sort of brandable asset that you have that you would be upset if someone else copied and made money off of, that should be trademarked. So obviously the brand name, the house mark, is a no-brainer, because if somebody takes your name, that's going to ruin your business if they have even a penny more of ad spend than you have. So you want to make sure that they can't just totally rip you off and take over everything that you've worked hard for. But the other elements in terms of the logo or any stylized logo elements that they may have, or the slogan, they can really think about it. If somebody copied your slogan, would it harm your business? Would it decrease your revenue? You have to think about those. If you have any sort of revenue generating brand asset, that should be protected with a trademark. Trademarks they're not free, but they're also not very expensive. So, it's not like patents, which are much more expensive and time consuming and things. So, people should definitely be protecting their trademarks earlier on. The earlier on that you deal with your trademarks in particular, the cheaper it is.
Thank you. And then just want to follow up about
Absolutely.
titles,
Please go
or
ahead.
what about like titles of books or curriculum names? If those are somewhat unique, is that protected by copyright, just by saying copyright, or would you recommend going ahead and registering those as well?
So copyrights and trademarks protect different types of IP. So when you have names, that's not going to be protected, or titles or brands, that's not going to be protectable via copyright. I mean, you can file a copyright registration on the copyright website, but they may even file it because copyright filings have very low oversight. They will really file a piece of toilet paper, I feel like, if you post that on their website. But at the end of the day, like, what's the point in filing something if it doesn't mean anything? So you cannot just file things willy-nilly. Like, they have to have some sort of legal backbone. So if it ever comes down to it, and they need to protect themselves and they filed a copyright as a trademark or vice versa, I mean, that makes no sense. They're not going to have that protection. So if you have a brand name or the title of curriculum or course that they've launched, things like that, that's all going to fall under copyright. Now, course content, course videos, methods potentially are patentable. Course content is copyrightable. So there's different layers of IP that they may have. The easiest way for a small business owner to identify what intellectual property they actually have and what needs to be prioritized to protect and what can wait potentially till they have more revenue is to do an IP audit. That's a very cheap way. You can, for a couple $100, you can identify every single IP asset in your business and decide what you need to do for the next 5 years to make sure you're protecting your income generating activities.
Wonderful. Thank you.
Lovely. Noel, do you have a follow-up question before we move on to Paris?
No, that was perfect. Thank you.
Lovely, lovely. So Paris, thank you so much for your patience. Welcome to the Brand Identity Design Podcast. We are live, just in case. We are live and we are recording, and this will be published as a podcast very soon once we are done with the show. So, do you have a question? Is there anything you'd like to contribute or clarify with my guest, Anna?
Thanks, Jason. Yes, actually, I had a question for you, Anna. I'm a founder of a new software as a service firm. So intellectual property for us becomes very relevant and very consequential because the underlying tech system that the team is building is going to end up supporting governments around the world. So just want to understand of how do we how do I, being the founder of the firm, protect the tech and when I say the tech system, I'm specifically talking about the artificial intelligence stuff, because there'll be intelligence involved in the system that will end up developing. How do we protect those from other firms copying the same code or using the same algorithm to generate the same predictive analysis?
Yeah, so there's a few different ways, to go about protecting new AI type of software. So, software is protectable via copyright. However, it's not ideal to just do copyright because, of course, that gets into the public domain. It's limited on time, low level of protection as well with copyright, copyrightable items. So, um, there's potentially patentable methods involved in what you're doing, in terms of what the AI is doing and whatnot. Software can be sterilized and then patentable. So, the first step that I would recommend, anybody in that situation is really go get a patentability assessment, go get an IP audit. And that a patentability assessment will be included and or recommended during that time. So, there's a lot going on with what you have with your brand. You also may have potentially, I don't know if it's an app platform, you might have things that need to be design patented, things like that. So, um, there's a lot going on in that type of business, in that type of sector, and there will very likely be multiple different types of IP that will be relevant. And with patents in particular, very, very tricky because the timing is very critical. With trademarks, it's kind of like the earlier the better. The earlier you do it before you launch, way before you launch, that's the best. But with patents, you can actually bar yourself from obtaining patent protection if you publicly disclose things too early. And there's different requirements for what constitutes public disclosure. And then in some countries, you get a 1 year grace period. So, if I have a software or a method that I made, AI method, and I go to a conference and I disclose it today, which is September 28th, 2022, I have until September 28, 2023 to get my patent on file in America. But not every country gives you that grace period. And then there's different types of patent filings too. There's provisional, non-provisional. Provisionals are kind of a placeholder for real patent, the non-provisional, real patent. So lots of strategy goes into protecting tech. And immediately you should be getting that patentability assessment done. I would recommend. Also, another thing that comes up is, you need to make sure you have correct NDA language when you are meeting with people, with all types of IP, but in particular in the tech sector, and in particular with patents. So, this goes for manufacturing as well. A lot of people in the US, they manufacture things in China and other countries. So NDAs are very critical for product-based businesses, but as well as tech sector businesses. So making sure that you have a very secure NDA and that information, you're advised appropriately by an attorney that can provide you with, who needs to know things. Everything should be on a need to know basis with IP in general.
Oh God, thanks for that, Anna. Just a quick follow-up. Uh, is do we have a rough estimate? I'm sure you would already know the answer, but is there a rough estimate of how much all of this costs if we do this like yearly 4 or 5 times a year?
So I always recommend businesses audit their business for IP about once every quarter. You don't need to see an attorney every time you do that. I would say you should definitely have an initial, when you launch a business or develop something significant in your business, meet with an attorney and see the different IP protections that you may need. And then, they can help you prioritize and budget that. But you should at least meet with an attorney once and they can advise you then accordingly. When you're developing tech, you're not going to need 4 audits a year, because you're working on one thing for a while, but it's different when you have an established business. It's very advisable to have an IP attorney that understands in your country, that understands your business, that really you get along with, so that you're able to communicate effectively. It is very critical in the tech sector in particular, or any sector actually, that you are able to articulate to your attorney properly what your business does, and they're able to comprehend it properly, because that is what you're being protected on. Basically, they need to write what you're protecting. So communication, find an attorney that you communicate with very, very well and that understands you enjoy working with them. It's many years process. So find an attorney that you trust and work with them long term. That's the best thing that you can do for your business. Then you don't have to deal with getting audits from 10 different attorneys, paying 10 different attorneys these random fees. IP audits are very cheap. They're a few $100s, and you're getting all of the information about what IP that you own, and then you can make decisions, more educated decisions long term for your business then.
Lovely.
Okay, sure. Thank you.
Paras, because you're kind of new to this whole thing, I just want to make sure she has answered all your questions. Do you have anything else you'd like to ask Anna? Don't hesitate. It's cool.
Oh, no, I think I have everything decent. Thank you so much.
Lovely. Thank you so much. I just want to say hi to Karen from Australia. Thank you for being here. She's a very close friend. I met on LinkedIn. How are you? And great to see you, by the way. Do you have anything you like to contribute? Ask Anna. Anything you like to clarify?
Thank you, Jason. Hi, Anna. Thank you so much for all your really informative information. I'm actually coming from Australia. I have actually done the business trademark thing a long time ago. I had a blanket business where I imported some blankets and sold it around Australia. So I have done something in Australia before, but I'm heading towards I'm an accountant on LinkedIn, but I also have a music persona on Instagram and Facebook, which I post quite a bit, and I've fallen into doing some volunteer radio work, and it's something I really enjoy. And I seem to get a lot of, well, not a lot of followers, but I'm getting more interaction internationally because I've got contacts over in America as well and around the world. So from that point of view, should I be looking at, like you said, contact someone that is an IP lawyer that you can trust? Do I look at getting support from Australia, or do I working with someone like yourself? Is that possible, or do I have to have multiple different lawyers?
When you have an international audience, it's always good to have lawyers that have international connections. Like I work with a firm in Australia. Actually, my old firm was based in Luxembourg, and we had like 22 offices. So we had an office in Australia that I work with now. But if you are an Australian citizen in Australia, and your major client base is Australian, then your primary focus should be protecting whatever needs to be protected in Australia. However, there are a lot of people, though, who work in Australia, Europe, India, and their audience is primarily in the US. Then it's more important to focus on working with a US attorney. But your Australian attorney, as long as they have international connections, which every other country except America, they all have connections in the US, because US is one of the most critical countries for IP. They will basically, you can do your registrations in Australia, use that as your home country, and then pull into the US. So there's some different strategies that goes into international protection, but in general, unless you're really focused on the US in terms of your audience base, you should go with your home country. And then
I guess sorry. No, go ahead.
Oh, go ahead.
I was just about to say I am locally based, but like my coach is from LA. She's from Australia but lives in LA, and this producer that I connect with, and so I've got a fairly connected audience on that side, and I guess I would probably be expanding it more. Yeah.
Yeah, so in that case, so you're, even though you're Australian, you're based in Australia, since your work is being maybe more targeted to the US, then yes, you would want to work with a US attorney. And
Okay. So
if
mixture
you
of
also
both.
want to be protected in Australia, you know, like we can do that as well. It just depends on
Okay.
there's different strategies. What we basically look at is timelines and costs of practicality. So whether or not we would use US or Australia as a home country and things like that, or concurrent filings, things of that nature. So as long as you have, you know, you're making the right connections and keeping people informed of when things, you know, what's going on in your business, what needs to be protected, either way, whether you contacted an Australian or a US attorney, at least a US attorney with international connections, you'll be fine. I will say, I'll caution if there's anybody else international in the listening to this, many US IP attorneys do not do any sort of global work. They only do US IP work. And that's fine because, like I said, US is a very critical country for IP, and there's plenty of US IP work. However, if you're international, you need to make sure you work with an attorney with international connections and international experience, because the connections get me preferred rates and all, you know, which local counsel I use in different countries. And also, if people have experience working with foreign attorneys and doing the global filings and things, you're going to actually get the proper expertise you need. If you work with an attorney who's only ever done basic US filings, then you will miss out on some of the critical protections that you need internationally. Even if you don't go forward and protect yourself in both countries, if you just do US or Australia or vice versa, you know, you want to have the options to be educated about all the different protections that you could have and make the decisions yourself. You don't want to be lacking in that education just because you know, your attorney just thought, oh, you wanted a US filing, it's one and done. It's really when it comes to any sort of international influencer or business or anything, it's a much more comprehensive strategy, in my opinion.
So, Karen, I had to put you on mute because I was hearing a little background noise. So, do you have a follow up question for Anna? Anything else you like to ask?
I was just going to ask the recommendation of the company that she was dealing with, but I guess I can message her after if that's okay, Anna. And also multiple different, like, because I have music and I'm wanting to move into writing and speaking at the same time, like umbrellaing my name in the best way. I guess that's maybe more of a branding question for Jason.
No, that's a trademark question. So yeah, that would be in the entertainment category. So there's strategy that goes into that as well, in terms of what we would tell you to invest more into and maybe what not to, depending on what's going to be most profitable and things. So the company I worked for is called Denmeyer, and they're on my LinkedIn profile.
Okay, I'll have a look at that. Thank you.
Awesome, awesome. Nice to catch up with you, Karen. Just in case, you know, if listeners on LinkedIn, if you want to schedule a call with Anna, the website is ana.app. Very simple, ana.app. If you don't have a pen or paper handy to make a note of this, I have already mentioned this under comments on LinkedIn. I've also pinned the link, to this URL on Clubhouse also. So feel free to reach out to Anna and ask for professional help, so that you can get a bit more clarity on things. On that note, Anna, I don't have any further questions, but you know, if you have a few more minutes, I know we went a little over the hour. I wanted to ask you a few rapid fire questions, if that's okay.
Yes, go for it.
Okay, so question number one: what makes you laugh the most?
Oh, this is a hard one. I feel like everything.
Okay, okay. Now, did you ever had like a childhood nickname, and if yes, what is
My childhood nickname was Nani, like Noni, because it was Madonna's nickname, and my uncle really liked Madonna.
it? Lovely, lovely. Thank you, Nani. Next question. Okay, what would you sing at a karaoke night?
Um, I don't know. I'm actually really bad at music. I only listen to TikTok music, so I don't even know.
Okay, okay. Next question, and this is gonna be my last. Okay, if you were a superhero, what power would you have?
Definitely to read minds. I think that would be the most useful.
Lovely, lovely. So if people want to reach out to you, Anna, so I think the website, the URL which I just spoke about, ana.app, is that the best way to reach out, or do you have any additional medium people can reach out to you? I think LinkedIn is one, and anything email, Instagram. What else?
Yeah, DM or you can go to callanalaw.com or just email to you can email my office info@analaw.com and whichever service you need you'll be directed to the correct attorney or anything like that. So I'm very easy to get a hold of. I have actually like a big team that answers all my DMs and emails and everything like that. So we're pretty responsive as long as we can help you. So, yeah.
That sounds cool. Anna, do you have any sort of promotions, events, speaking engagements which you like to promote during the show?
I do not. Just I'm, just trying to consistently post on socials and I try to provide a lot of free valuable content. I do a lot of IP work or a lot of IP content and business content. If anybody has video requests and things, you can leave them as comments in my videos and my social media team will add it to the list of videos that we're making. But other than that, not really.
Awesome, awesome. So, if do you have any final thoughts or anything you like to share with the audience before we wrap this up?
Yeah, so I'll just say one thing, you guys. I'm just starting to grow my LinkedIn. So if you've not already connected with me on LinkedIn or followed me on LinkedIn, please check out my profile. It's just my name, Anajuneja. It's linked in the ana.app link up there as well. And if you guys learned anything in this podcast or learned anything from my content anytime you watched it, please give me an endorsement on LinkedIn for IP. And that's it, though. That's all I have to say.
Awesome.
I really had fun during this podcast, though. So thank you for having me on.
Absolutely, absolutely. I had fun, learning from you, and such informative and educational. I think it's going to help a lot of people out, Hannah. So thank you so much for all the clarity which you provided today. I also want to say thanks to all the listeners hearing us live so far, either on LinkedIn, Clubhouse, Spotify, Apple, Google, wherever you're listening from, and whatever time you're listening at, morning, evening, night, afternoon. Thank you so much, for your love and support. I truly appreciate this very, very much. Next week, so my show is broadcasted every Wednesday at 12 Eastern Standard Time. Next week, I'm going to have a guest. Her name is Alicia, and we're going to speak about creating viral content. I've never actually been into that spectrum of viral content, so I want to actually educate myself on this and see, where it's going to head. So thank you once again. Thank you, Anna, and all my listeners. You take care of yourself, and I'm gonna have my closing song. And have a nice day. Bye.
Thank you. Bye.